I'm Natalie Karam. I'm one of the co-presidents of the UNSWTV Law Society. I'd like to welcome you all here today for the second part of our Hail to the Chief series with Sir Gerard Brennan, the former Chief Justice of the High Court of Australia. I will now hand over to Professor Keith Mason to begin the proceedings.
Thank you. Well, I would like to add my welcome to you, Sir Gerard, and thanks that you have come. You were born in Rockhampton in 1928. You graduated BA LLB at the University of Queensland, and you were admitted to the bar in 1951 in Queensland. What inspired you to enter the law and to become a barrister?
Well, I don't know that there was anything that was inspirational as such. I didn't really have much of a chance when I come to think of it. My father was a judge in Rockhampton. I can remember at a fairly early age when his associate was away for a day, I went into court as his associate. And I was there, I suppose, intermittently from then on. And I always thought that the court atmosphere was a delightful atmosphere, and I very much wanted to be a barrister. It was a good thing that I did change that ambition, because when I first went in there, as some of you may have known from reading a speech that I made when I was sworn in, I think, that I picked up the indictment the first day and promptly charged the Crown Prosecutor with rape. So I needed to improve from that point onwards.
Your father was somewhat of a controversial character in politics and law. Please tell us a little bit about him and his influence upon you and your own career.
Yes, he was a very controversial figure, really. My father was, he was a solicitor practising in Toowoomba, and he stood for the Labor Party and succeeded in ousting the then leader of the opposition. And so he was something of a notable figure in the Labor Party, which was at that time rather bereft of professional membership. And as time went on, it appeared that the Labor Party had a majority, I think, of only one in the House. And there occurred what was known later as the Brennan bribery case, when a number of people approached my father and offered him a large sum of money if, being a professional, he would change over to a party that they thought might be more attractive to him. Well, he arranged for police officers to attend his house, and he was able to procure the evidence which resulted in their ultimate conviction. So he emerged as something of a hero in the party, I gather, and was shortly after that he put his hand up for being appointed as a judge, and he was. He was always controversial in the comments that he made, from the bench as well as elsewhere. But you say, what influence did he have? He had an enormous influence on me because of his utter integrity. That, above all, is my recollection of my father. He died when I was, 21, I think. But in terms of integrity, he was an absolute model. And so I was always extremely grateful, not only for that, of course, but also for his love, because we had a very close family relationship. And that, I suppose, is the main influence that I can remember from him.
So Gerard, you took silk in 1965. You were the leader of the Queensland Bar. You served as the president of the bar. You were president of the Australian Bar Association. You practiced in Queensland and elsewhere, including Northern Territory and Papua New Guinea. Could you tell us about an interesting case you were involved with during that period of your professional career?
Well, I suppose I should say something about a High Court case. One of my first High Court cases was a case called Harrison Wagner. It was, it's in the CLRs, and it was at the end of the time when the interstate carriers were doing rather well. They were going across the borders and claiming the protection of Section 92. And our client was Mr. Albie Harris. He used to cart wool from Hughenden in North Queensland to the wool stores in Brisbane. But on the way he used to go down to Coolangatta, cross the border to Tweed Heads, do a Yui, and come back to Brisbane. And so he said, "Can't touch me." So there were a number of prosecutions against him, and we decided we'd take this particular one because if he won that, then all the others would collapse. And so we went before the High Court, and it was a very interesting day. I can remember the case for a number of reasons, but perhaps most importantly for the influence that Sir Owen Dixon had upon the other members of his court. It was, I suppose, about 3:30, 4:15 in the afternoon, when Sir Owen Dixon's little nervous cough, for which he was noted, brought silence to the whole court. And he then made an observation. I can't remember the exact terms of it, but essentially it was, should we decide that something that was undivided is indivisible? Some profound comment of that kind. At all events, nobody wished to do anything for the rest of the afternoon until they could get hold of the transcript to see the precise words which he had used. And the next morning it was quite clear that that was the way in which the court was going to decide the case. But in terms of a influence of one judge on his colleagues, it was a remarkable demonstration. So that was one case that I found interesting. I suppose most of my early cases were probably interesting criminal cases. Very interesting.
Did you appear on both sides of the record in criminal matters?
I appeared for the prosecution only once, and that was in Rabaul, where I was briefed to prosecute a large number of the Tolai people who were involved in the murder of a district commissioner. It was something of a cause célèbre because it arose out of a land dispute in the area around Rabaul. And shortly it meant that a young man had been deputed to murder this district commissioner by stabbing him with an old bayonet, and a number of those who were involved in the plan stood around while this took place. And the trial went on for the best part of 6 months because it consisted very largely of a series of voir dires where the police officers gave evidence against each of the several accused, and I think there were probably something like 16 to 20 accused, represented individually, largely by members of the Sydney Bar, whom I came to know and like very much. And it was notable, I think, for two things. One was the remarkable way in which the Chief Justice of Papua New Guinea at that time, Sir John Minogue, conducted that trial. It was a model of patience, of balance, of understanding of the issues. He was quite remarkable. The second thing was that in this area, I'm sorry, I knew I never threw much light on things, but in this area there was considerable political upheaval. Early in the trial there was a protest procession of about 6,000 people outside the court. The police advised me, and I told the other counsel and the judge, that it was not expected to be violent because it was obvious that a large number of women and children had come in for this procession, and that indicated that it was not going to be a violent demonstration. But nonetheless, it was demonstrable that there was a tremendous political feeling about it all. Well, the trial, as I say, went on for many months. And I think the local people became quite convinced that this was fair dinkum. In the end, the Chief Justice convicted, I think, probably about 12 or 14, something like that, not all of them. And then it was time to impose the sentences. Well, at the time of the sentences, they couldn't even fill the gallery of the court. It was a wonderful demonstration of how the application of the law, even in the most contentious areas, can settle disputes, quell concerns, and bring a sense of law and order and peacefulness to a community. And it was largely due to the extraordinary performance of John Minogue.
Did you ever feel personal fear in the course of conducting the law or administering the law?
No, I think I can say truthfully I did not. And perhaps I was particularly privileged in that regard. I remember visiting the ultimate appellate court in Germany, vested with criminal appeal jurisdiction, and in the antechamber to that court there were the statues of those who'd been murdered by terrorists opposed to the application of the German criminal law. I think we've been very fortunate in this country.
Yeah.
Very fortunate indeed.
You represented some interests in an arbitration in Fiji conducted by Lord Denning. What was he like, either based on your experience there or generally? You must have known him, and what was his contribution to the law in your opinion?
I mean, they always say, don't they, that the 20th century was the century of Denning, and in a very real sense it was. Yeah. He was a remarkable judge. I can remember saying to him once in his chambers in London, it was just after Laker Airways case, and I said, "My Lord, but if such and such and such and such took place, what would you say then?" "Ah," he said, "we'd have to wait and see, wouldn't we?" Which I think was indicative of the way in which he saw where justice lay and then went to identify the methodology which led to the just result. And that was somewhat of a revolutionary way of thinking at that time, I think. Yeah. He was a quite remarkable man to appear before, utterly at ease and putting everybody else at ease, and with a wonderful ability to understand issues and to ultimately arrive at the issues for determination in a very crisp fashion. I think he was one of the great judges to have influenced the development of the common law. Not perhaps so much in finding the passages in the judgments, but in opening up the way of thinking about problems and seeing the law as an instrument of justice as well as an intellectual construct. And that was, I think, one of his great contributions.
In 1976, you were appointed the founding president of the Administrative Appeals Tribunal, and in 1977, you received a concurrent appointment as one of the foundation judges of the Federal Court of Australia. In 1979, I had the privilege of being led by Sir Maurice Byers, the Commonwealth Solicitor General, in Drake's case number 1, which upheld the constitutional validity of holding those dual appointments. It must have been exciting for you to have been there at the birth of these two institutions. Has the AAT evolved as you expected, and what in your view has been the long-term impact of establishing a standing administrative appeals tribunal in Australia?
Well, I suppose first I should thank you and Sir Maurice for preserving my appointments.
I think the judges always take more credit than the barristers.
I think the appointments were two fascinating appointments. They were at a developmental stage of not only administrative law but law generally in Australia, particularly public law in Australia. The AAT, at the same time as I was appointed as president of the AAT, I was also at that time president of the Administrative Review Council. The two offices at that time ran together. Later, correctly, they were separated. But there are a number of issues that had to be resolved when the AAT was first established. I can remember one quite dramatic day when we were dealing with a deportation case. There was jurisdiction in those days to consider an order for deporting a person who had been convicted of a criminal offence. But the power ultimately rested with the minister, and the AAT's jurisdiction was limited to making a recommendation for reconsideration. Well, when the documents arrived, I was furnished with a copy of the minister's policy about deportation. The applicant, who was the person who was seeking some consideration of his case, hadn't been given a copy of the policy. So I refused to accept the minister's policy and said that under no circumstances should documents reach the tribunal which had not been made available to the applicant. Now that was not anywhere in the Act, but it was established by that case, and it was a rather dramatic event, I think, because for the first time I think the bureaucracy discovered that there was an independent wind blowing, and that was an important feature. It led, I think, to the ultimate realisation that the new administrative law package, as it was called, was blowing the winds of legal orthodoxy, as I said, through the corridors of power. And that was important because up until that time, many of the administrative decisions that had been made were made in accordance with departmental manuals. And there was no guarantee that the departmental manuals bore any necessary correspondence with the empowering statutes. So that when the AAT was established and we were furnished with members who were very good lawyers, a number of judges and then some extremely competent senior members, all of a sudden the departmental manuals ceased to have the coercive effect that they had in the face of any contrary statutory provisions. And ultimately, of course, there was the question of the way in which we dealt with policy, which was adumbrated in Drake No. 2. And I think that in some way isolated the AAT from becoming too closely involved in the formation of policy and in the political process, and allowed the determination of issues in a more judicial fashion than the administrative method. All of that, of course, had been foreseen by Sir Anthony Mason and others in the preliminary reports which had led to the creation of the AAT. Now you ask, how has it developed and what do I think of its development, as it were? In the years when I was president of it, which were the first years of its existence, we were concerned to ensure that it established its own independent reputation. For that reason, I was always resistant to the vesting of what might be regarded as the mass jurisdiction areas, particularly veterans' affairs and social services problems. After I left, my successor, Justice Darryl Davies, was not so concerned about those issues, and those jurisdictions came to be vested, and I think rightly so. And I think the AAT has done a remarkable job in ensuring the administration justly of statutes which are intended to confer benefits on a mass of Australian people. So I'm very happy with the way in which the AAT's jurisdiction has been expanded, though it was not an expansion which I courted myself in the early days of its existence.
On the looking at the other side, the Federal Court, which in its early days was a smaller, compact unit under the leadership of Sir Nigel Bowe and its first Chief Justice. Has the growth of the Federal Court and its obvious dispersal nationally affected its capacity to function as efficiently as it might? And what is your view about whether it should have a standing appellate division?
Well, to answer your second question first, I'm firmly in favour of having a standing appellate division. I think it's desirable on two counts. One is that if you have a standing appellate bench, you develop an ability to work collegially, which is important in the development of a total judicial philosophy in dealing with appellate matters. Secondly, I think that with an appellate division, you can provide a degree of expertise which is specific to review of decisions below, as distinct from taking people from their day-to-day work at first instance and translating them temporarily onto an appeal bench. So I'm in favour of that. Has the Federal Court been able to discharge its functions? I think it's done so remarkably well. It was created, of course, to be in relief of the High Court, amongst other things, in the taxation areas, because the appeals up until that time used to go to the High Court, and occupied the justices there in first instance work quite heavily. The Federal Court has become very much the appellate tribunal for tax matters, and indeed was developing very greatly, I think, in general commercial areas, although the Wackham decision, I think, put some limitation on its ability to perform those functions. And regrettably, I think there's a little bifurcation of the commercial jurisdiction now, which is not altogether satisfactory.
You were appointed a Justice of the High Court of Australia in 1981 and became Chief Justice of that court in 1995, serving in that office until the eve of your 70th birthday in 1998. What were the most significant changes in the way the court handled its business during your time there?
Well, I suppose the introduction of special leave arrangements were the most notable ones. Up until that time, there were appeals as of right in cases which involved a certain amount of money, even if they didn't involve any issue of principle. The special leave jurisdiction, I think, was important because it allowed the application of a filter to ensure that the cases which went to the High Court were those which demanded the limited resources which the court could offer. And also, I think, which had the effect of imposing on intermediate courts, on some intermediate courts at all events, the role of being the de facto ultimate court in a large variety and group of cases. So I think that was perhaps the most significant change. Other changes, the court's insistence on acquiring its own transcription service was quite important, I think. The court had been accustomed to using the Commonwealth's transcription service, which was sometimes delayed and not always accurate. But with the development of a transcription service within the court's own areas of responsibility, it was possible to ensure that where there were quotations from earlier authorities, for example, those quotations could be recorded in the transcript, and those who were involved in either preparing arguments for the next day or in the writing of judgments subsequently could use those transcripts as the basis for their research. And that was, I think, a very important development in the procedures. Another change, which may be of significance to those who are thinking of graduating and moving to an associateship in the High Court, is that there was a time when the tipstaves in the High Court were usually dear old digs who were likely to be very good at finding ways around all sorts of problems and getting whatever they could for the judge. But in time, that changed so that we were able to move to having the tipstaves who were young graduates, and then ultimately to the melding of the two roles of associate and tipstaff. So that the staff of each justice now consists of two associate tipstaves who share the functions that were once divided. And I think that's important because it enhanced the research capacity of the justices. And then finally there was the creation of a very active library research cadre. And they were extremely good because they would be given research tasks which could be used by all members of the court. They were usually given these assignments not in relation to narrow or specific points, but general issues. And the work that they did in providing research papers was, I think, a valuable background for the writing of judgments. So I think that was important, also as one of the methods that was changed. And finally, I think I'd like to mention one other one. I finally got J.D. Merrills to agree to putting the starting page of each case on each page of the report. That had taken, what, 170 volumes or thereabouts to produce, but it was quite a change, and ultimately Jim Merrills agreed.
Many hours.
Saved many hours over the
clicking
years,
back,
yes.
Yes.
But those were, I think, the main changes that I'd think of.
In 1985, one of your serving colleagues, Lionel Murphy, was convicted of attempting to pervert the course of justice. The conviction was set aside on the basis of a misdirection. There was a new trial and he was acquitted. There were calls for his removal from office, and legislation was introduced and passed that would have set up some commission or committee to inquire further into the facts. In July '86, Lionel Murphy announced he was dying of untreatable cancer. He returned to the court for only 1 week of sittings before dying in October 1986. How did these events affect the internal functioning of the court at the time, and how significant is personal collegiality between the justices of the High Court?
It didn't affect the arrangements of the court except in the necessary way, that is, whereas the name of Murphy J would appear in proposals to sit in any given sittings up until that time, once the prosecution was launched against him by the Director of Public Prosecutions, he ceased to sit and ceased to be available for rostering on cases. Then, after his acquittal, but while there were still some political issues to be resolved, he announced, as you've mentioned, that he was coming back to sit on the court, and that he would sit there as necessary and as he was able to. He would not sit beyond the stage at which he was not able to perform his functions. This led to a public controversy between himself and Sir Harry Gibbs, then Chief Justice, as to whether he should return, which was, I think, unfortunate. Lionel did return, and he did sit on some cases, and indeed 2 of the judgments which he had written in relation to cases at that time were delivered by Sir Harry Gibbs and myself an hour or so before Lionel ultimately died, as a matter of urgency to ensure that those judgments were published effectively. Personal relations, I think they were always very satisfactory. Certainly, we were all affected by the concern that we had that one of our members was being prosecuted criminally. And that concern, I suppose, was most acute when one of the issues that had been reserved for the Court of Criminal Appeal in New South Wales was referred to the High Court, and we had to sit and make a determination on it. I suppose our main concern at that time was in relation to a rumour. No, well, it was more than a rumour really. It was something that was attributed to the then Attorney General, that he understood that we would not sit with Lionel if he came back to sit on the court. That was utterly untrue. There was never the slightest suggestion that the members of the court would not sit when he returned to sit on the court, whenever he chose to do so. It was his constitutional right and authority to sit on the court, and it was certainly not something that the members of the court ever contemplated diminishing or denying. So that was, I suppose, the main problem of the Murphy affair so far as the court itself was concerned. How important is collegiality generally? I think it's very important. Just as an indication, in the years, or many of the years that I spent on the High Court, 4 of us, Justices Dawson, Toohey, Gaudron and myself, used to go for a walk every lunchtime. We'd go around the parliamentary triangle and blow some of the cobwebs away and talk about shoes and ships and sealing wax. And then we'd come back and sit in the afternoon, perhaps deliver judgments in which we quite substantially disagreed. But the mutual respect that I think all of us had, one for the other, was, I think, one of the remarkable features of a court which was, I think at that time, if I might say so with respect to my colleagues, constituted by a wonderful group of people. So I think it's quite important.
In Mabo, you made no bones about expressing views about the injustice of the then well-established doctrine of terra nullius. You said that, quote, whatever the justification advanced in earlier days for refusing to recognise the rights and interests in land of the indigenous inhabitants of settled colonies, an unjust and discriminatory doctrine of that kind can no longer be accepted. The expectations of the international community accord in this respect with the contemporary values of the Australian people. Sir Gerard, how do judges discern what are the contemporary values of the Australian people, and how do they decide when the law should be changed?
Contemporary values, first of all. I might say that in my first draft I had another word instead of contemporary there. Yes. I had egalitarian. It was suggested that I should change that to contemporary, and I was happy to do so. But perhaps that is an indication of the significance that I place on contemporary. I was not then talking about something that was suddenly conjured up in the press or on a doorstop interview, something which hit the headlines for a week or two. I was talking about the sort of values that inform the Australian community, ones about which we ordinarily have no great argument. We didn't have any argument about egalitarianism. We always regarded ourselves, I think, not always in practice, but at least in theory, we always regarded ourselves as being an egalitarian community. that was a contemporary value. And so I think that was one of the fundamental concepts that I had in mind when I was speaking about contemporary values there. When do judges decide to change? Judges decide to change, I think I said in Mabo, if I remember correctly, when the existing law demonstrates an injustice in its application, and there is a prospect, consistently with judicial method, of reformulating or reforming it. Now that's very general terms, but nonetheless I think that's probably the way in which it has to be expressed, because one can't predict in advance the precise operation of any rule of law until you get the concrete facts before the court. But if I might say so, I'm not really wanting to explain or defend any of the language in that or any other judgment that I wrote, because it always seems to me that judgments are of necessity. They have their own lives. Once the judge has written the judgment, cade quaestio, end of the argument. If it's any good, it stands on its own feet. If it's defective, the defect should be exposed. And it's not for a judge subsequently to say, oh, but really you ought to give this judgment a better run. I don't think that's a function for the judges at all, never to comment upon their own judgments. And so, subject to that, that's what I'd say.
Some have attacked Mabo and other decisions of the High Court during what I might call the Mason and Brennan Chief Justiceships as being activist and unsettling of the rule of law. What would you say in relation to that attack?
Oh, I think activism is a very easy term to use. It always concerns me to think that it probably has to do with the result of a case rather than with the intellectual exercise that led to the result. The judicial method has to do with the way in which a result is reached. It has nothing to do, in a sense, with what the result is. It may be of interest to the judge to see what the result is on the application of the law, and sometimes, in the instance that I was just discussing, it may be necessary to consider whether the operation of the law does produce an unjust result. But at the end of the day, it has to be integrity in the application of the judicial method, which is the ultimate justification for the operation of the rule of law in a judicial system. And so, as for criticism of Mabo, if there are criticisms of Mabo or of any other case, I would think that the criticisms, if they had any validity, have to be directed to the steps, the logical, legal steps that were taken in reaching the conclusion, not in the conclusion itself. Activism is oftentimes related to an unexpected result, unexpected by the person who attributes the activist adjective to the case. The unexpected result without reference to the methodology by which it was reached. And so I don't find it a very helpful term.
Your judgment in Quinn's case is, I think, a justly famous one. I remember the case because I argued it before you.
Successfully?
Yes. I remember equally losing the case very dramatically before the Court of Appeal under President Kirby, but I thought we might have a better run in the High Court. Certainly those instructing me did. Your judgment stressed that, quote, the court has no jurisdiction simply to cure administrative injustice or error, and you put Wednesbury unreasonableness in a very tight box. On my understanding, your attitude to judicial review in this and other cases, including natural justice cases, was based upon seeing the judicial role as an implied grant of authority from the Constitution and Parliament, rather than being located in what I might call the common law judicial breast. Do you agree with that? And why has Australian law and English administrative law got so far apart?
Well, Mark Aronson would probably like to answer that question. But for myself, I'd say, yes, in general, I'd agree with the proposition. This is sometimes referred to as a separation of powers approach. I don't know that it's so much a separation of powers as a limitation of powers approach. Where, if you have an exercise of executive or administrative power by the repository of the power, what is the jurisdiction of the courts to interrupt the operation of the statute by which the power was invested? Well, I'd have thought that the only justification there can be is if the exercise of the power is not authorised by the statute which invests it. In other words, that there's a limitation on the administrative power in question which the court then proceeds to declare. That's the straight Marbury and Madison exercise. It's not something which the courts, as it were, assume to themselves as they were on white horses going around doing deeds of derring-do. It's a case of the courts applying what Parliament intended, namely that this power is one which should be exercised in accordance with natural justice, etc., etc. And if the courts limit themselves to that function, then it seems to me the courts are doing no more than applying the rule of law to the exercise of executive power. But that is not, I think, something which the courts themselves assume to themselves. It's something which the courts perform just in the ordinary course of applying the rule of law. Now, if there's a difference between Australia and England, as there seems to be in this field, I can only say that I think the Australian methodology is preferable. The English now are speaking in terms of proportionality, for example, and I don't know what the difference would be in the question which a court would ask itself at the end of the day between, is this exercise of power proportionate to what it should be, or how is that different from saying, is this a reasonable exercise of power? How do we find some criterion for the intervention of the judiciary in the exercise of executive power? Now, that theory that comes, as it were, from parliamentary authority won't do when you get to areas of power which don't depend on statute, for example, the prerogative powers. But after all, the courts have always defined the limits of the prerogative powers since the days of Coke in the 17th century. So if again the court says, hold on, this power doesn't extend to such and such, as in De Keyser's Hotel, then well and good. That's simply the court again applying the law, defining the limits of a particular power. And that seems to me to be precisely what courts do.
I'll ask one more question and then there'll be time for perhaps one or two questions before we have to round matters up. we've been talking about the generations of the Brennan family. Your son was involved in, one of your sons was involved in a very well-known inquiry into a Charter of Rights. Are you disappointed that the notion of a Charter of Rights has been shelved, at least for the foreseeable future?
No, I'm afraid I'm a fence-sitter. I'm not sure whether Frank approves of my being a fence-sitter. No, first of all, I think that some of the recommendations that were made by that committee have been implemented, not in the way of creating a Charter of Rights, but in dealing with the procedures for the creation of statutes and so forth, which I think are good moves. But the creation of a charter, the conferring of jurisdiction on courts to exercise what some would regard as political powers, I'm still wondering. I mean, the total justification for it has to be that we can no longer place our trust in the political process sufficiently to see that justice is done in important areas of human rights. If that's so, then I suppose the judiciary have to come into some sort of play. But that brings the risk of politicising the judiciary, which I think is somewhat frightening. So I'm a fence-sitter. And I'm sorry, but that's as far as I can take it.
Questions? Anybody like to ask Sir Gerard a question? Yes.
How do judges respond to the personal or political pressure following judgments such as Mabo without having to defend the judgment itself? Because you said that it's never the role of the judge to have to defend the judgment itself.
Yeah.
But obviously following a decision such as Mabo and media reports that our backyards can be taken over, how does one respond to that sort of pressure?
You don't. Just simply that. You don't. There's a wonderful article written by Sir Frank Kitto on why write judgments that's worth reading. And in it, he says every judge must be aware that when you write the judgment, the sparks will fly up and criticisms will come. And how do you respond? Not at all. And I think that's a very wise thing to do, apart from anything else, because I think the public overall understands that the judges don't reply. And therefore, when there are criticisms, I think they're oftentimes received with a certain reserve, as though people would say, well, maybe that's right, maybe it's not. Certainly, I regret the fact that there is inadequate media coverage of judgments. And I see that the Chief Justice of Victoria has recently said that she wants to publish, I think it's a weekly newsletter now, of what the courts are doing, so that people will really get to understand what the courts are about. And that applies particularly, of course, to sentencing cases, which are very difficult. But again, research shows that when people are given the full facts of a case involving a sentence, they more often than not agree with the sentence that's been passed. But I think the silence of the judiciary is one of its great strengths.
Yes.
What are your views on having judges, guiding opinions in appointing new judges in courts such as the Federal Court? I believe you're on one of those panels.
What are your views about judges having a role in recommending the appointment of judges?
Appointment of judges.
Yes.
I'm in favour of it, naturally, because I chair now a panel which gives advice to the Attorney-General on appointments to the Federal Court. Now, why am I in favour of that? Because I think that there's no way in which a Federal Attorney-General can know the candidates for appointment to the Federal Court. Sure, they might know Joe Blow down the road or Mary Jones around the corner and might think that both of them are good. But in terms of a spread of people from whom a selection can be made. The Attorney-General of the Commonwealth has no chance of knowing them. If you therefore have a committee which is charged with the responsibility of winkling out those who are appointable and considering their relative merits, I think there is a lot of desirability in that. The problem, if I might say so, is the problem of confidentiality, because it's difficult to get oftentimes a full picture of a particular candidate without revealing to somebody outside that that person is being considered. And either that person may not wish to be considered or may not wish it to be known that is considered and is not in fact appointed. So confidentiality is a problem about it, but subject to that, I think the system overall is a desirable one.
Well, sadly, we have run out of time, and for my part, I must thank you, Sir Gerard, for being entertaining and informative, and I'll invite Natalie to propose a more formal vote of thanks.
Thank you, Natalie.
On behalf of everyone here, I'd like to thank you, Sir Gerard Brennan, for what was a fascinating discussion. What I gained out of it particularly was the importance of collegiality in the legal profession, as well as your insights into Mabo and what informs contemporary values, as well as on aspects of judicial appointments. So I thank you for your time today. I have a small gift to give you as an expression of our gratitude and appreciation. It's a biography of Sir Alfred Stevens, who was the 3rd Chief Justice of New South Wales.
Oh, thank you very much indeed.
Thank you.
Thank you. Well, thank you, Natalie, and can I just say to the undergraduates here, good luck with the exams later in the year.
Well, that concludes the second but not the last of the series. Thank you.